The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning. Welcome to your North Carolina Court of Appeals. My name is Judge Chris Dillon. I'll be presiding today, and also on the panel are Judge Lucy Inman and Judge Darren Jackson. We have two cases on the calendar this morning, but they involve the same parties. And so we'll hear the first appeal first, but it's the Town of Apex versus Beverly R. Rubin, and we will hear the appeal in the case our file number 20-304 first. And we're ready to hear from the appellant. And I understand you're going to reserve 5 minutes for this first argument. Is that correct?
Yes, Your Honor. Thank you.
Well, proceed when you're ready.
May it please the court, Matt Learberg here with my colleagues Kenneth Haywood, Joan Davis, and Troy Shelton on behalf of the appellant in these cases, Miss Beverly Rubin. These two appeals turn on one question. Did the Town of Apex have any right to stay on Miss Rubin's property after the October 2016 final judgment was entered in this case? Under controlling precedent from this court and our Supreme Court, the answer is no. Title to Miss Rubin's land reverted automatically back to Miss Rubin at the moment that final judgment was entered. After that point, the town had no right to continue to stay on Miss Rubin's land, but the town refused to leave and refused to obey the final judgment. And so here we are 4 years later, still battling the town over the same issues that were finally determined over 4 years ago by this court in this case.
Mr. Learberg, if I can
yes,
just jump in.
Please.
In this case, Judge Collins determined that because Ms. Rubin didn't expressly seek relief for trespassing, because Ms. Rubin didn't seek injunctive relief from Judge O'Neill, that sort of the absence of discussion of those concepts in Judge O'Neill's judgment precludes the relief that Ms. Rubin is seeking. And can you speak to A, do you contend the town is trespassing, and B, procedurally in the what I call the direct condemnation action 304, what are Ms. Rubin's methods of relief, and does she have to bring a separate trespassing action? That's a mouthful of questions, I know.
Sure. So unfortunately, a private landowner is not able to bring a trespassing case against the government, against the municipality. So while it looks like a trespass, it's actually just an unconstitutional taking. But more to the point, Ms. Rubin did everything she was supposed to do. When the private developer sought to develop that vacant piece of land, and then the town brought a direct condemnation action using the funding from that developer, Ms. Rubin took every action that was available to her. First, she put the town on notice and said, just 3 weeks after the complaint was filed, and said, don't start building because I'm going to challenge your right to take at all. She filed an answer and raised that same defense. But the town started building anyway. But our courts have already determined who bears the risk in that situation. The party that bears the risk is the government. So under the Chapter 40A regime, most municipalities use 40A. Under that regime, there's a 30-day waiting period, right? So the municipality puts the property owner on notice, and then the statute expressly provides for an injunction. You can bring an injunction, and that kind of stops everything before the municipality can get ahead of itself. But Apex has a special law that allows it to use the DOT's provisions under Chapter 136. And for that reason, there's no injunctive relief provided there. So what the town did is they were able, under the law, to start their project upon filing that condemnation action. But under Thornton, they bear the entire risk of that. And the way that our Supreme Court said it in Thornton, They said that if the government decides to go forward with a project while the litigation is pending, it might, quote, find itself embarrassed by its having done so prematurely. So the law already allocates that risk to the government. Ms. Rubin did everything she was supposed to do. She developed the evidence to show that it was a private taking, and she won in a final judgment. So at that moment, when the final judgment was entered, I mean, the thing that's frustrating is we have yet to hear from the town, what was Ms. Rubin supposed to do at that time? The final judgment said everything it needed to say. And this is again the Thornton case and the Pelham case interpreting it later by our Supreme Court. A final judgment that goes further and says, not only do you not have a right to be there, government, but you also are subject to an injunction to leave. Thornton says that is redundant. It's redundant to have an injunction in the final judgment. I mean, if Judge O'Neill had said, not only do you not have a right to be there, you also have to leave, the courts would have said that second part is already assumed. It's redundant. That's what Thornton stands for. And that has to be the law. It has to be the law. Because otherwise, if the town retains a right to be there, even when there's no public purpose, then what is the remedy for the landowner? Just compensation? That's what the town would have this court do. The town today wants this court to write public purpose out of the Constitution and is asking this court to be the first court in the country to hold that your only remedy is just compensation. As we said in the brief, heads I win, tails you lose. If it's for public use, you get just compensation. If it's for private use, well, we're there anyway, so it's an inverse condemnation, you get just compensation. Now, Ms. Rubin did everything she could. The only other thing she really could have done is engage in self-help. And as soon as the final judgment was entered, Ms. Rubin said, there were communications with counsel, maybe that would be an option. As soon as that issue came up, the town responded by sending a threatening letter. And I'd like to point the court to it in the record because I think it's important. The letter is, it's a February 13th, 2017 letter. In this case, it's documentary exhibit 1. The town does two interesting things in this letter, and this is kind of after the final judgment, around the time just after the reconsideration order. The town says, Ms. Rubin, if you or a contractor so much as touches or disturbs that pipe in your property, you will be subject to civil and criminal prosecution. So what was Ms. Rubin to do? Well, she's a licensed attorney, and she doesn't want to be hauled into court by the town for a misdemeanor, even though the Constitution and the final judgment said she would be allowed. The other fascinating thing about that letter is it's one of the key places where the town has painted itself into a corner and explains why that there were so many other options for sewer to run to this property. I mean, at the time of that Section 108 hearing, and this is August 2016, the land was vacant. They were just starting to build the neighborhood. There's a letter in the record, and it's the record supplement, page 292. And the letter says that as of late July, 4 lots had been pre-sold. The neighborhood was just getting started. And the town's attorney said, quote, I'm not arguing we can't undo what we've done. And indeed, there weren't any other options. This other letter we're looking at documentary exhibit 1, the town says, well, we could pump and haul from the manhole. We could attach another pipe to the manhole that's not on Ms. Rubin's property and pump and haul from another location. We could install a permanent pump and go up and around Ms. Rubin's property. We submitted an affidavit from Don D'Ambrosi. It's at record supplement 200. And Mr. D'Ambrosi also says, yes, there are other options to get sewer. There is a reason why they decided to go across Ms. Rubin's property. And it's crass. The reason is to save money. They did it to save money.
Well, that's been, I mean, that was sort of resolved, I guess, to turn be a private take or private purpose. I want to call your attention to a case one of my colleagues actually found, Clark versus Asheville. It's 316 NC 475. In that case, 316 NC 475, and I'm on around page 486. In that case, one of the contractors of DOT dumped some waste or rocks or whatever on somebody's land, and it was held to be a private purpose. But what the court held was you have no claim against the DOT at all. You've got to sue the individuals that actually did it. It said, and they don't have a defense where we were acting under the authority that DOT gave us. They said private parties, these contractors would not be relieved, or even the agents, any agent of the governmental entity. The court said the government entity cannot act beyond its authority. It's an inanimate object, cannot do anything beyond that. So if something's done outside their authority, it's the private people that did it you have to go after, and you can't go after, in this case, the DOT. So, I mean, is that right? And if so, I mean, what is the remedy here, I guess, for your client? Is it to go after the individuals that actually put the pipes down in the ground and tell them to move it? Because, I mean, can you sue the town for trespass? Because I go back to Thornton. Thornton says if the DOT's opinion is erroneous, the defendants are entitled to have the proceeding dismissed, leaving them with whatever rights they may have against those who have trespassed upon their land. Which you admit you can't sue the state or you say that you can't sue the town for trespass. And so who do you go after? What's your remedy is what I'm trying to understand.
I think the fundamental problem is that when the government purports to take under its direct condemnation authority, and that taking is found to be for a private purpose, the title reverts back and the government has an obligation to restore the land to the condition it was before the taking. So I think there are two separate things going on. First, the government has an obligation to stop infringing Ms. Rubin's rights. And the courts must and do have the power to fashion a reasonable remedy, such as telling the town to stop its occupation, remove the pipe within a reasonable time. That's what we're asking for. Now, I think what Your Honor is raising is, yes, but maybe there are damages in the interim. So perhaps the Clark case is getting to the idea of, well, Ms. Rubin, you've had 4 years of unlawful occupation. Who is to blame? She can't sue the town. Maybe she could sue an underlying contractor.
Well, let me interrupt you real quick. It cites a case called Shingleton, which is 260 NC at page 458. In that case, it said, the owner of the property cannot maintain an action against the state or any agency. It follows, therefore, it cannot maintain an action against it to restrain the commission of the tort. However, the landowner is not without a remedy. When public officers whose duty is to supervise and direct the state agency's attempt to threaten to invade, they are not relieved. They personally are not relieved of the responsibility by the immunity of the state from suit, even though they act or assume to act under the authority and pursuant to the directions of the state. Likewise, private parties would not be relieved of responsibility when they assume to act under such authority. I mean, this case suggests that you got to sue the people that did it. You can't sue the town itself because they have immunity. I'm just reading what the Supreme Court says. I'm not commenting on how wise it is or whatever, but we're bound by whatever it means. So I don't think you consider that.
If I could
So
just
Judge Dillon, I don't understand that or the previous case that you raised to be raising an exclusive remedy. I think it's true that kind of an ex parte Young type suit where you go after the official as opposed to the government itself asking for relief, that could work. And in fact, we did try that. So after the town refused to abide by the judgment, we sued in federal court. We sued under 1983, and we said the developer and the town, they're engaged in a conspiracy here. They're working together to violate her constitutional rights, and it has to stop. The federal court said, let's see what the Court of Appeals does in North Carolina first, and dismissed it without prejudice. So, you know, we're not asking for money damages because of that. We're just asking for the land to be returned to its original condition. I think Your Honor is probably right. We could sue the proper official in the government and get an injunction of that against that person to comply with constitutional rights. But Ms. Rubin should not have to do that. And I don't think she does. It's been 6 years of litigation. Ms. Rubin has the right to tell the town not just to remove the pipe, but there's another source of the injunction here. The town needs to comply with the final judgment. There is a rule of law issue in this case, and that is that this case is over. It should be over. There's a final judgment from 2016 upheld on appeal. It says the town has no right to be there. Under Thornton and under Town of Midland and under Town of Apex versus Whitehurst and other appellate cases, the town has no right to be there. The title reverts to Ms. Rubin. the remedy has to be that the courts have the power to tell the town to leave. The courts have to have that power. And it doesn't have to be a separate lawsuit. It's just the enforcement of the existing judgment.
Mr. Learberg, is it your position that the court has the power to hold the town of Apex in contempt?
Yes. Yeah. I mean, Mr. Farrell at times has raised several procedural barriers like, well, you can't sue the town for trespass, you can't hold the town in contempt. But at some point, the courts have to draw a line and say, even the government has to obey the law and has to obey a final judgment. And the town has absolutely acted with contempt to the judiciary. The town not only opposed our effort to have them comply with the judgment in this case, but filed an entire separate action that we're going to talk about after this one, asking for really just the flip side of the coin of the relief in this case. The town is just multiplying litigation because I think the town thinks you can't fight City Hall, and we're just going to bury this individual and just keep litigating forever.
And you said at the very start, no trespass action against a municipality because of sovereign immunity. That was before Judge Dillon mentioned the Clark case. And I'm sure you've explored this, but I just want to understand. Is it possible for the town to waive sovereign immunity because it charges for sewer and water? There is a statute, and I cannot remember the statute number now, that provides that municipalities waive sovereign immunity in various ways, and one includes charging for water and sewer. Or is the kind of immunity that Judge Dillon mentioned flowing from Clark, which is like a legal fiction, something that can't be waived?
So, Your Honor, I don't know the answer. I don't know the answer as to whether the sewer, whether charging for sewer can constitute waiver of sovereign immunity. It's absolutely true that when the government acts more like a private party, then there can be waiver. And when it acts more like a government, then there is no waiver. But in some ways, I think it's beside the point for what Ms. Rubin's asking for, because she is not asking for money at this time. She can, other than attorney's fees and costs, which is provided under the statute, she's just asking for the town to leave and comply with the judgment. And I don't think any of these cases in any immunity doctrine says that the government can ignore the Constitution. If the Constitution applies to anyone, it applies to the government, right? I mean, private parties can't take, governments take. And so, I don't think we need to look any further than the Constitution. And in fact, there's a whole other issue that Judge Collins never reached, and that's the United States Constitution. The United States Constitution is a separate font of authority and power here that the town has never explained how you get around the case after case after case from the United States Supreme Court and around the country that says you may not take for a private purpose, and to sanction it, to allow it. One of the cases says that would be legalized theft. That's exactly what's happening here. It's legalized theft. So we could get kind of torn up by all of the state doctrines and trying to find the right remedy under state law. But at the end of the day, if we decide, if the courts to decide for any reason that the state constitution doesn't give the courts power to tell the government to stop breaking the Constitution, the federal Constitution absolutely does. There's no immunity to claims. I mean, under quorum, you can sue even if there's no statute. We should be able to sue under the state constitution or under the US Constitution. So this case really does pit procedural machinations by the town against just the fundamental fact that no matter what a case or statute says, the Constitution is pretty clear on this.
Let me address that. Well, the Constitution says the state can't take property unless for public use. So if they're taking it for private use, what are they doing? What's the claim? Isn't it a trespass claim? They are occupying property they don't have no right to occupy.
We don't need a claim. We don't have any claims. We've never sued and we don't need to.
Okay, well, what if they just put the pipes in the ground and never did a condemnation case? What's your claim?
Right. So in that case, that's kind of an inverse condemnation, right? And that's one of the arguments that the town has come up with, is trying to refashion inverse condemnation into something it isn't. So your Honor's absolutely right. if the government were to take property or intrude or make a physical invasion on someone's property, the Constitution requires, it says that's not allowed, right? So there has to be some remedy. And so what most states have done is to make a statute that provides some procedures around that. And in this case, it's 136-111. And it's often called the inverse condemnation statute. What the inverse condemnation statute says is, if the government intrudes on your land and it's for a public purpose, you can sue and you can ask for money.
What if it's a private purpose? What if they just put something on your land and it's a private purpose? What's your remedy? First of all, what's the wrong? What's the civil wrong? It's not a taking, because can only occur when it's public. What is it besides a trespass?
Your Honor, that is a question, and we look through the statutes to try and find what statute or common law says that there's a problem there and gives you a procedure for it, and there really isn't one. The government usually doesn't intrude on someone's land for a private purpose without filing a claim. Where does that leave us? It leaves us with quorum, right? It leaves us with a suit directly under the North Carolina Constitution against the government, to which they are not immune, saying you are not allowed to do what you're doing. So inverse condemnation is an important part of this of the world of condemnation, where a landowner can get money retrospectively for a prior invasion. But that's not this case. That has nothing to do with this case. And the Supreme Court's Wilkie versus Boiling Springs certainly doesn't say otherwise. Instead, if there were a physical invasion without a direct condemnation action, there would be a quorum claim to kick them out. And the other thing that I think the town is missing is, and they kind of led Judge Collins to hold, that you could somehow have a direct condemnation and inverse condemnation for the same thing. That's not the case. I mean, the statute says you can only file an inverse claim when, quote, no complaint and declaration of taking has been filed by the condemner. Well, that's the opposite of this case, because there was a direct complaint and taking filed. And this court read the statute and said it means what it says in DOT versus Mahaffey in 2000, saying an inverse condemnation claim should be dismissed as, quote, unnecessary and redundant when there's already a direct condemnation claim. So I think that all of this case law suggests that there may be lots of remedies for Ms. Rubin, but we know that at its most simple, the government should be required to abide by a final judgment and leave the property. The law says the title reverted to her.
Is there any case that held that when the government trespasses on your property, it gives rise to a quorum claim? It's a constitutional claim. Is there a case that says that, or would that be the first time that we've recognized that to be a type of a remedy? It'd be a remedy instead of trespass, because, as you said, there is no trespass claim against the state. You have to sue the individuals that are actually doing it. But you're saying that there'd be a claim against the state because of the violation of the Constitution. I'm just trying to understand logically where you're trying to get us to do, and if it's been done before.
To the best of my knowledge, standing here right now, and I'll look while Mr. Farrell's speaking to see if I'm forgetting a case, but it's not that common for the government to take land for a private purpose. So we're already in kind of a smaller sliver of cases, and usually they would do so with a direct condemnation action. Probably the closest case we could get to is Wilkie, where the court said that if a landowner just wants money for inverse condemnation, they can bypass the discussion of private or public purpose. But I'm not aware of a case directly saying that. However, there has to be a remedy. I mean, what quorum stands for is the idea that constitutional violations must have a remedy. And the courts have the power to do something about it. And we kind of, as you can see in our motion to enforce the judgment in this case, we scoured the statutes, looking for what procedural mechanism might help and convince the court that it has the power, even though most notably the court has the power under the Constitution and inherent authority. But we found several options. The condemnation statute has kind of a necessary and proper type language that's in 136-114. The court can have a writ of assistance to enforce its decree under 1-302, Civil Rule 70, mandamus. The labels don't necessarily matter. I think what's important is that the remedy we're seeking, which is not damages, we're seeking to get the town to leave and abide by a final judgment. This court absolutely has that power. That's what it boils down to.
Let me ask you, a quorum claim, if I remember, that only arises if you have no other remedy. Is that correct?
Right, it's a fail-safe. If none of these other remedies...
Well, the Supreme Court in Clark said, it follows and you cannot maintain an action to restrain the state from the commission of a tort. However, the landowner is not without a remedy when public officials whose duty is to supervise and direct the state agency attempt or threaten to invade, you can sue them. So would that defeat your quorum argument, the fact that the Supreme Court has recognized you do have a remedy, go get the contractors to remove the pipes that they put in, or the individuals that did it? Would that defeat the quorum claim because you do have a remedy?
Standing here today, I'm not sure I know if who the town used, if it hired a private contractor or not.
Wouldn't they be an agent of the town, whether they were a private or not?
Right. I mean, it would seem to me that if the answer coming out of this case is we need to go through the historical records and find some poor contractor that was just following orders and sue them years later to say to take the pipe out, I can't imagine that that's the best outcome for the state of the law when the town is the one driving this train. And the thing is, we do have a remedy. We shouldn't get to quorum. I mean, quorum is a backstop, but we shouldn't get that far. The problem is that these cases are talking about damages, right? I mean, they're talking about suing for trespass for damages. And here we're not asking for damages, we're asking for the town to leave.
Mr. Learberg, of all the various sources of authority that you laid out in your motion to enforce the judgment, I think one of them was a writ of mandamus, petition for writ of mandamus.
That's right.
Isn't that discretionary? And looking at that avenue, for example, if this court agreed with you and we remanded this case to the trial court, then does the trial court get to say, I'm weighing the equities and I'm deciding that, regardless of all the things that happened before, we're going to move on and we're going to see that there's, people living in these neighborhoods now. And when I balance the equities, I just not going to give that to you. I mean, if he left being subject to the trial court's discretion for the remedy, or are you asking this court to enforce it? And if so, under what authority?
Your Honor, we saw what happened when the trial court had discretion already. This is our second time to this court. We ask on behalf of our individual client, who is a single person, that this end. It's been 6 years. This court absolutely has the power to reverse these orders and remand with instructions. And we've tried to be reasonable all along with the town. We're not, we have yet to engage in self-help, even though it sounds like under these cases, we could go out there and dig up the pipe. We don't want to do that. So this court absolutely has the power to remand with instructions to the trial court saying, town, you must obey the final judgment. And that means within a reasonable time, you need to reroute the sewer so as not to perpetuate this constitutional violation. There continue to be options for them to do that. And this court absolutely has the power to tell the trial court to do that. And we ask that if this court is going to reverse, to be as explicit as possible in those instructions, because you don't want us up here a third time and we don't want to be up here a third time. This has to end after 6 years. And that's the other thing, Your Honor, to circle back with Judge Dillon's question, and then I'll sit down. If it's true that there are these actions for trespass and we could, it's established that these folks don't have a right to be there, whether it's the town or the contractor, isn't the natural implication of that Ms. Rubin does have the right to self-help? That seems to follow. And that means she could hire a contractor to come out with a bulldozer and dig it up. I don't think that's the best option, but if that's where we end up, then we will do that. We can and will do that. We have tried to protect these 50 homes that the town has allowed by continuing to let the neighborhood develop and issue building permits and issue certificates of occupancy, even after the final judgment. We're trying to find a way to respect those innocent parties from getting caught up in the dragnet of the town's machinations. So if there are no further questions, I'll reserve the little bit of time I have for rebuttal.
Thank you so much. We'll hear from the appellee.
Thank you, Your Honor. David Farrell here representing the town of Apex. Appreciate the opportunity to be with you this morning. There's a couple procedural and standard review issues that are critical in this case. And Judge Inman, you started to hit on that kind of at one of your last questions. But this is a court of an error correcting court. And so you're reviewing Judge Collins's orders to determine whether he committed reversible error. And for the most part, his decisions are discretionary. And so these are key factors here. And so we certainly believe when the orders are viewed in the right procedural and standard review context, that they should be affirmed going forward.
Is it your contention that there's no de novo review of any of the legal conclusions that Judge Collins made in his orders?
Well, good question. First of all, the findings of fact were not contested. There was no contest of the evidence supporting findings of fact. And certainly, you have de novo review of conclusions of law, but Judge Collins applied discretion to whether or not to invoke inherent authority and whether to invoke the 136-114, for example. You gave a great question about whether if we remanded, couldn't he and shouldn't he view the equities here and then decide that the pipe stays. He's already done that. And
well, but if I could just interrupt you on the findings of fact.
Yes.
Finding of fact 12, given the court's dismissal of the original condemnation complaint as null and void, the installation of the underground sewer line was a physical invasion and taking a defendant's property by the town, not subject to a condemnation complaint, and thus was an inverse condemnation of an underground sewer easement. I have a hard time accepting that that is a finding of fact rather than a conclusion of law. That seems like legal analysis to me. And so even if the plaintiff didn't challenge that finding of fact, are you saying that, and even though the plaintiff has challenged that legal analysis, are you saying that that's binding on us?
Well, I think what I would say, certainly when the judge says that a set of facts resulted in an inverse condemnation, that is something that is a legal conclusion. And sometimes you have findings of fact that include things that sound like legal conclusions and vice versa. I think the important thing to remember here is Judge Collins is, this is unlike a lot of the cases that Rubin cites, because in the cases that Rubin cites, there's been a pleading where a landowner has raised injunctive relief and has raised a remedy of having the title revested and having property free and clear. And then the judge in their judgment addresses those issues and either denies injunctive relief, grants injunctive relief, includes language like revesting and free and clear, things of that sort. We don't have that in this judgment. What we have is a finding by Judge O'Neill that the condemnation complaint was null and void. And that is a finding that's really undisputed. It's language right out of the judgment. And so,
but is that, if I can interrupt you, for Judge O'Neill to find that the condemnation complaint is null and void, isn't that a conclusion of law?
No, because Judge O'Neill said those words. It's in the judgment. If the judgment says the complaint is dismissed and it's null and void. And so when you look to determine what those words mean under case law, I think it's the Hobson case we cite, null and void means it's as if it never occurred. And so that is the words Judge O'Neill put in her order, quite frankly, were drafted by Ms. Rubin's attorneys. And so this case turns on the pleadings and the judgment. Rubin wants to argue overgeneralized concepts. And if you don't reverse, somehow landowners' rights are impacted to contest condemnations in this state. And that's just not the case. If you look at the other judgments that have been issued here, when parties properly raise claims and relief, courts deal with it. I mean, a 108 hearing at its core is where the landowner who's challenging the right to take in this case is required to raise any and all issues other than just compensation that they want the court to address. Rubin chose not to address the pipe in the ground. The pipe was installed over a year before Judge O'Neill held her Section 108 hearing. Rubin did not ask the court for any relief as it relates to the pipe. And the cases they cite, and what they've basically done is argue that there should be this new judicial concept created in this case called self-executing injunction or self-executing vesting, which doesn't exist in our law. And so the cases that they've cited, I think there are about 10 or 12 in their brief that they cite that deal with cases where the courts have discussed injunctions are because the parties raised it. Here, Rubin did not raise injunctive relief in her pleading, and so Judge O'Neill did not give her injunctive relief. And her pleading is essentially consistent with her pleading correspondence to us, which is in the record, I believe page 69 through 72, where she wrote us a letter and said, if you guys are going to proceed with construction, we will be forced to file for damages. She said damages. She didn't say injunction. She also said she was going to move and quickly to have a hearing on the issue, which never occurred. And so,
do those omissions in your position waive her rights because she said that in a letter?
I'm so. Did you say does it waive her rights?
Yeah.
Well, I don't think a letter written from one lawyer to another necessarily waives rights. What I think it does is put in context the pleading that she filed. I mean, the pleading speaks for itself. It does not request injunctive relief, and it doesn't request revesting and those things. So if she doesn't plead it and doesn't at some point ask Judge O'Neill to deal with it, and then Judge O'Neill doesn't deal with it, and Judge O'Neill gives her exactly what she asked for, which is a dismissal, you know, I don't know what else we expect our Superior Court judges to do, but to review the issues that a movement like Rubin puts before them and then rules. And, you know, Rubin had lots of options here. And this is one thing that, you know, she has said here today and has said, well, the town's never told us what our remedies are, and we really don't know what to do other than to file the complaint that we filed. But the case law speaks to the contrary to that. The cases outline the rights a landowner has to, if they do contest the right to take and how they should proceed. And obviously it starts with injunctive relief, seeking that. The town did proceed under Chapter 136, and you know, Rubin referred to that today and has in the past as some sort of, you know, sinister right that the town has that nobody else has, that gave us the right to use immediate possession and quick take here. But that's just not supported by the law. Apex has had has had the right to proceed under Chapter 136 since about 1987, and they got it through a special act. There, just in a quick search, I found 55 other local governments and local municipalities that have the right to proceed under Chapter 136, including Wake County towns like Zebulon, Raleigh, Holly Springs. There's east to west, urban to rural. There's towns and cities all over the state that has the right to proceed under Chapter 136. I've always viewed it not as a right to give a town like Apex quick take, because that's another kind of misnomer from Rubin that they use this for quick take authority. Towns in this state have had quick take authority for sewer projects and water projects, among others, for at least 33 years. 48-42 was amended in 1987, and they probably had it before that through another statute in 160A. So the use of Chapter 136, in my experience, is more about how damages are calculated and used at the damages phase, and whether or not the condemnor that might be bringing water and sewer to a piece of property that increases its value can use that as a part of the damages analysis. So that's really what Chapter 136 use is all about. But that's important context, because Chapter 136 is the grounds that the town used. And the Thornton case, I think, deals with this issue very clearly. Thornton distinguishes between whether or not a landowner has a right to enjoin a condemnation action versus whether or not a landowner has a right to enjoin construction of facilities in an area that may be condemned under Chapter 136. The case specifically dealt with the situation where DOT filed a condemnation action. The condemnor ended up building a road, expanding a private road, making it public, and then expanding it, incurring cost in doing so. And when the project was about 95% complete, the landowner filed an answer contesting the right to take. Interestingly enough, moved for injunctive relief, which Rubin didn't do here. What the court said is, and other courts have said this since Thornton, that you can't file an injunction to stop a condemnation action, because you can obtain that relief just by raising a defense in the lawsuit. So the courts have said we're not going to entertain a separate injunction action if you're trying to enjoin the condemnation action itself. What Thornton does is recognize a landowner's rights to seek an injunction to stay construction. It specifically referenced the fact, what happened in that case was the trial judge found the private use, not a public use, for the taking, and entered an injunction relying on a previous Supreme Court case of Batts. Thornton said that the judge erroneously relied on Batts and said that because basically the landowner did not move for TRO prior to construction, that the injunction would not lie. And so they go on to say in Thornton that a landowner, if they're correct, they can obtain dismissal of the petition, but not an injunction in this case, because again, construction had already.
That's the question, because they say you can seek dismissal, and it leaves them with whatever rights they may have against those who have trespassed upon their land. So why wouldn't that include them suing the individuals or just digging up the pipe if they want to? Because they might not be able to get an injunction to stop the DOT. DOT's done. I'm sorry, the town Apex is done, but how do I deal with that last sentence here? I mean,
sure. No, that's a great question. And that's where, in our case, it all turns on the pleadings and Judge O'Neill's judgment. And when she found the condemnation complaint was null and void, and it's as if it never existed, what you're left with is a pipe under Miss Rubin's property. And I do want to make sure the court understands the nature of this pipe. The pipe was installed by a bore method. So essentially the surface of Rubin's property was not disturbed at all. The town went on either side of her property, dug a bore pit 18 feet deep, and put a steel casing under her property 18 feet deep, and then put the sewer pipe inside the casing. So the town, for maintenance reasons and even in installation, did not have to disturb the surface of her property. The pipe will be maintained and serviced through the manholes. It's I think the total land area that was ultimately believed by the town to be part of this inverse taking was about 0.036 acres. And it was installed around July 27th of 2015. But what we have, Judge, is a pipe, a physical invasion by the town. And it is settled, and this is where I think we certainly have disagreements with Rubin's position here. When you have a physical invasion by a condemnor, it is not a trespass. That's the McAdoo case. It's settled law. But what you have is a taking. And the Supreme Court has recognized that in a number of cases is that what you're left with was with a physical invasion is a taking when a condemnor does it. And so then you take a look at the Wilkie case, which was the Supreme Court case from 2018 on the issue. And this is kind of what I think several of the judges have talked about is what is the remedy and what should the court recognize this self-executing constitutional type argument.
Mr. Farrell,
Those issues were both addressed in Wilkie, and Wilkie is directly contrary to Rubin's position here today. What Wilkie did was Wilkie recognized that they talk about the constitutional provisions. In fact, the Court of Appeals in Wilkie found that when there is a physical invasion that's for a private purpose, not a public use, the Court of Appeals held that the inverse condemnation rights under, in that case, it's 4851, but the language is identical with Chapter 136. It's 136-111. It said that that when there's no public purpose, you can't have an inverse taking. So the landowner doesn't have that right. So we're going to remand to the trial court so they can do this self-executing constitutional argument. But Judge Irvin, writing for a unanimous Supreme Court, reversed that and rejected that theory and said, no, that's not the remedy for the landowner. There is no public use element to an inverse condemnation remedy. So that what they recognized in Wilkie is that a landowner has a remedy, and the remedy is just compensation under, in our case, it'd be 136-11. And so Irvin has in the Supreme Court has already ruled on the issue that Rubin's asking you to do something different on today.
Mr. Farrell,
And again, this is where I think it's important to kind of go back to making sure we are focused on the review here, because this is a review of Judge Collins' consideration of whether or not to essentially adopt one of these new theories or adopt a position directly rejected by Wilkie and not recognized by Thornton to require removal of a pipe that Judge O'Neill refused to order removed. And so that is, I mean, that's a critical review issue here.
I think Judge Inman has a question. So
Oh, I'm sorry, I didn't see your hand. My bad.
can you hear me?
I sure can.
Okay, good. So in Wilkie, the landowner wanted to sue for money, right? Wanted to sue for money. And the Court of Appeal said, can't do that. And the Supreme Court reversed and said that this landowner can sue for inverse condemnation because in that posture, there's no requirement for a public purpose. Isn't Ms. Rubin different than the landowner in Wilkie in that she's saying, no, thank you. I don't want to do that. So I'm not in the category of the landowner in Wilkie. I don't want to do that. And if I don't want to do that, then public purpose is required. And isn't that a distinction? And number two, what's your response to Mr. Learberg's question about self-help? And if Ms. Rubin, on a matter of principle, wants to stop this constitutional violation, as she alleges, what's to stop her from going and pouring concrete in those pipes?
So I'll take the first question first, and that is, Judge Irvin specifically rejected the constitutional, this constitutional action because he found that there was a remedy. He did not recognize injunction as being a remedy, and correct, the landowner in Wilkie didn't ask for injunctive relief. It doesn't appear. But Rubin is in no different situation than any of the other landowners who have come before us in the cases that have been cited, particularly the Thornton landowner. The Thornton landowner wanted an injunction, and the court found that because they didn't move prior to construction, that they weren't entitled to an injunction. And we also, have cases, and again, I keep coming back to this, but it's worth mentioning again. If she's telling us today that all she wants is an injunction, that is the only way that she feels like she'll be made whole, there was nothing stopping her from pleading injunctive relief when she filed her answer. She could have moved for a TRO and an injunction. And the fact that we filed under 136 doesn't change that. I mean, the evidence is clear that she was put on notice 2 months before the condemnation action was filed by being notified of the town council's resolution. She then had another 3 months before the pipe was actually installed in the ground. And the town did not do any construction activities under her property until after she filed an answer where she didn't plead injunctive relief, didn't request revesting, didn't request free and clear. And, again, there's no cases that stand for the proposition that this is some sort of automatic relief that just flows because you contest a condemnation, or automatically flows because you now raise constitutional rights. I mean, I think it's important to note that if Judge O'Neill's judgment did not go and do what they wanted it to do, they had remedies there. They could have asked her to reconsider it and clarify. They could have appealed it. If they'd appealed it, maybe there would have been a more direct de novo type review of some of these issues instead of considering them in the context of Judge O'Neill Judge Collins looking at this, 4 years later under the guise of inherent authority and discretionary writ of mandamus and things of that sort. There's remedies here that she chose not to exercise. But as far as the self-help goes, again, if she didn't ask for an injunction and a judge Superior Court judges didn't give it to her, there's an ordinance. And what we did with the letter was, again, they didn't raise injunctive relief. They didn't ask for the pipe to be removed. And then after they got Judge O'Neill's judgment, they wrote us a letter essentially threatening to self-help and plug the pipe that was serving residents of the town unless we began paying them, some sort of rental fees and doing some other things, despite the fact that we were appealing the judgment and things of that sort. So, I know they want to characterize this as some sort of threatening letter. All we did was inform them that there's an ordinance in place that protects public sewer pipes. And here, this one served a neighborhood, and it's against the ordinance to go block it. And that's all that was done here. Yes, Judge, I'm sorry. I keep looking at the camera.
I just didn't want to forget my question. When you're talking about, she didn't seek injunctive relief and you cite that in Thornton, and earlier you had said, letters from lawyers don't mean anything. But is it the town's position that by failing to seek injunctive relief before the pipes were installed, that Ms. Rubin waived her right to injunctive relief?
And Judge, yeah, that is correct. What I wanted to make clear is that, if some lawyer writes a letter prior to filing a pleading, that's not necessarily a waiver. But if she doesn't request injunctive relief, again, we cite this in more detail in the brief about what Rule 7 requires and how you seek relief under our rules of civil procedure. And Rule 65 certainly, and there's cases that interpret Rule 65 as to what an injunction looks like. We all know what an injunction looks like when we see it. There was not one here. And so with no injunction, coupled with no legal authority for this concept that they've created, really just to try to explain away their failing to ask for an injunction, which is self-executing and, those types of things, revesting and things like that, that's just not supported by law. And I want to point the court to the one case that I thought was interesting that's been cited. It's City of Statesville V Roth. And in that case, that's a 48 case. But the important thing about that case is that was a case where the court dealt with injunctive relief. And I think this is a good example of what a judgment could look like that would give a landowner like Rubin the relief she now says she's due. In that case, they asked for the petition to be dismissed, the complaint to be dismissed, along with permanent injunction, revesting of title, taking property free and clear, etc. And what the judge in that case held is that the petitioner's complaint be dismissed and the property sought be acquired is revested. So the language of the judgment required revesting. It goes on to say, the petitioner, the city, is enjoined and restrained from appropriating the respondent's land, from going upon the land and maintaining lines across the land. And they are ordered to remove the same from the property and restore the same to its former condition. So that's an example of what an order looks like that does the things that Rubin is now asking you to give her extraordinary relief where she didn't ask for it. And the cases don't, again, they don't provide for an automatic, you get all these things. I mean, the Constitution does not include any remedies. And if you look at the case, particularly Wilkie, and the case, I think it's Sale v. At the time it was Highway Commission, is another case that they cite that recognizes this kind of, if you don't have a remedy, if a statute doesn't provide a remedy, that you can have this constitutional claim where a court can consider what remedies should be awarded. It specifically says where a statute doesn't provide a remedy. And so I believe Collins, in his review of O'Neill's judgment, properly concluded that Chapter 136.11 provides a landowner a remedy where there's a physical invasion and it's for a private purpose. And look, condemnor is like a town. I'm sorry, was there a question?
Yeah, I have a question, Mr. Farrell. Ms. Rubin did, in fact, though, challenge the constitutionality of the taking. Is that correct?
Well, if you look at her judgment, I mean, her answer, she does raise that we don't have a right to be there. She raised the Constitution. But what she didn't do is then ask for the remedies that would flow from that violation.
So is it your contention that every litigant who challenges the constitutionality of a taking has to file an injunction, or they've waived basically the decision of whether or not it's a public purpose? Because what flows from your argument is, since she did not file for an injunction and you had quick take power, that basically she's left with only getting damages because she didn't ask for an injunction.
Well, I think what I'm saying most principally is that merely raising a constitutional claim does not automatically qualify you for a list of remedies. You have to ask for the remedies you want, and every case is different. And so if a landowner wanted to protect itself, not only would you move for an injunction, but you would plead the things that the Roth judge put in that order, and that is revesting, taking free and clear. They want to talk about these generalizations, but every case turns on the actual judgment that you're asked to review. And so if I were representing a landowner, I would move for injunctive relief. I would plead revesting. I would plead all of those issues that are in the Roth judgment. And it just didn't happen here.
Okay, let's take that one step forward, one step further. So if Ms. Rubin had asked preliminary for an injunction and the trial court had turned her down, would she have then lost the power to challenge the public versus private taking because the project's already started. I mean, I don't see how this is supposed to work going forward. It just seems like to me you're asking for a rule that would require any litigant that is challenged the constitutionality of a governmental action has to ask for an injunction, or they've waived the right to challenge the constitutionality and they're just left with their damages.
Well, that's not what I'm arguing. What I'm arguing, and I think Thornton spells this out. I mean, you can challenge the right to take and obtain a dismissal, but Thornton recognizes that if you want to enjoin construction, you should ask for it, and you should ask for those other things. I think, but again, what I'm not asking for a general rule here. What I'm asking the court to do is, in their review of Judge Collins's discretionary rulings, I mean, whether or not he's going to exercise inherent authority and whether or not he's going to make up a procedural rule for something that's really not procedural, these are discretionary calls. And so, you know, the context of this review is, did Judge Collins get it wrong by following Thornton and following Wilkie and refusing to remove a pipe that had been installed 4 years earlier when the landowner didn't ask for it and didn't get the relief they wanted before final judgment, and then they come in after final judgment and want relief they didn't ask for? That's the real crux of this case, and which is why I think we said this in our brief, and I'm repeating it here. You know, this court, in reviewing the context of that Judge Collins order, you know, really has a clear path to say, look, we're not going to give landowners who don't ask for relief after the fact. And, you know, certainly given the way the town proceeded, we didn't rush out and the day after we filed this complaint, you know, say, hey, we're using quick take and we're taking this easement. She had notice. She had the ability to effect some remedy. She said she was going to file a motion quickly and she didn't do it. She said she was going to seek damages, not injunction. Then she filed an answer and did not seek injunctive relief. Then the town proceeded. And I mean, you know, the town incurred probably $300,000 worth of costs burying this thing under her property, trying to, you know, work with her in this regard. And so, you know, and now you've got a pipe in the ground that she didn't ask to remove.
Wrap up your argument because you're going into,
I'm sorry.
and you'll have more time in the next appeal.
Yeah, understood. I think, again, I'll just wrap up by saying the review of this case rises and falls on the language of her judgment and then how Judge Collins interpreted that, not some general principle going forward. But certainly I can, in my next round of argument, try to address in more detail the landowner's procedure going forward.
Okay, thank you. Thank you. Mr. Leroy, rebuttal?
Thank you, Your Honor. Judge Collins had no authority to ignore or set aside Judge O'Neill's final judgment that had already been upheld on appeal. And Judge Collins had no discretion to sidestep constitutional rights that had already been established. The fact that there are findings of fact and conclusions of law that the town wrote in the 4 orders on appeal in these 2 cases, those are all conclusions. There's no fact that's necessary other than following the judgment that's already in place.
So is a big part of this case how we interpret Judge O'Neill's order or ruling? What did she actually order? I mean, we're interpreting her judgment because that's what Judge Collins purported to do, which I guess would be a question of law. What does that order mean? What does that first judgment mean?
That's
And
right.
I'll assume you would say it means that she ruled that this was a private taking and the deposits get returned to the state or to the town and she gets her property back. That's how you would interpret the judgment.
Actually don't think the order says what it says. I don't think there's anything to interpret. The part of the order, the null and void piece, I think is important. The town says that Judge O'Neill said that the condemnation action was null and void. Not true. That sentence, it's very specific. What the court says is
their claims. Yeah, I read it. Their claims.
It's not the claims. It's not the legal claims. They say the claim to her property, meaning the right to have her property. So it's that fundamental. It's the town's right to be there at all that Judge O'Neill said was null and void, not a procedural question about the lawsuit. With respect to the injunction, when Ms. Rubin answered, there was no pipe in the ground. So there was no injunction needed to say to take the pipe out. What Mr. Farrell and the town are saying is she should have asked for a construction injunction. That question as to whether you can waive a right by not raising it at that time has already been decided in town of Midland. And I want to read this sentence because it answers exactly.
Well, let's go ahead and start the next hour if that's okay, because you're into your time too. So let's go ahead and I don't know if we're going to reset. If Mr. Sora, can you reset the clock? 30 minutes, okay? You want to reserve 5 of these minutes, is that right?
Yes, Your Honor.
Okay, go ahead. So we'll start. I'm now calling the appeal 20-305. So let's go on forward.
Thank you, Your Honor. I was going to ask if I could borrow for my next 30 minutes, but I'll try and keep it within the overall hour. And you can, of course, exercise your discretion to tell me to sit down at any time. I do think this sentence from the town of Midland versus Morris, it answers Judge Jackson's question directly. It says, we are wholly unpersuaded by Midland's argument that even where a city flagrantly violates the statutes governing eminent domain, that the city can obtain permanent title to the land by fulfilling the purpose of a condemnation before final judgment on the validity of condemnation is rendered. That's it. That answers the question. That's binding authority from this court, from the 2011 Town of Midland case. So, you know, our position is that Ms. Rubin didn't have the ability to get an injunction. The town says she did. It's kind of potato. It does not matter because Town of Midland says that if a town is going to use the great power of quick take, it has the great responsibility of bearing the risk if it turns out that the town was wrong. As Thornton said, the town bears the risk of being embarrassed by the fact that they went forward. That is where we are today. In the half hour or 35 minutes that the town just presented, not once did Mr. Farrell have an answer for your self-help question, Your Honor, Judge Dillon, not once. The town has no answer other than this kind of incorrect inverse condemnation theory. They have no answer to say that Ms. Rubin can't go out there and fill the pipe today. Again, I don't think that's the most practical outcome, but if that's where this court ends up, then that's where we can go. We can go and she has title to the land and she can exercise her remedies. I think that would be a messy outcome, but it sounds like the town has no answer to oppose that. Shifting gears to the 2019 case. Oh, I'm sorry, Your Honor.
You think I know how to unmute myself? Do you believe that this court's decision in 20-304 will drive the court's decision in 20-305?
Yes.
Okay.
There's nothing left.
Okay. And 304, I don't know about the dates of Judge Collins' orders, if 304 was entered before his order in 305.
It was actually a consolidated hearing. Judge Collins recognized that they were the same case, so we just had an all-day or a half-a-day hearing, and he entered orders really all on the same day.
Okay. In 305, unlike 304, you have interlocutory appeals.
That's correct.
Can you address why this court should resolve the motion to dismiss? And I can't remember what else.
Declaratory judgment.
Declaratory judgment, yeah.
Yes. Oh, I understand what you're saying. Yes, there was a motion to dismiss, and then the town asked for a preliminary injunction. Those are the two orders that are on appeal.
Yes, right.
Right. So, I mean, if we win in the 2015 case, there's nothing left for the 2019 case. If this court says the final judgment means that Ms. Rubin has the right of self-help, or if this court holds the final judgment means that the town has to remove the pipe, then the orders in the 2019 case have to be vacated and there's nothing left. On the kind of jurisdictional question, these orders have to be immediately appealable. And the question is was the 2015 case, was it pending or not at the time the town filed this action? So a little bit of the timeline might be helpful. We knew, Ms. Rubin knew, that she had to act fast once the Supreme Court denied Mr. Farrell's petition for discretionary review in the first case, because the town had already signaled to us that they weren't going to abide by the final judgment. So we prepared our motion to enforce the judgment, and when the Supreme Court remanded to this court and then remanded down to the trial court by virtue of just kind of the mandate issuing, we immediately, within a day, I think, filed our motion in the first case. Sometime later, I think weeks, maybe months, the town then filed this 2019 case asking for declaratory judgment that the outcome in the 2015 case was wrong and asking for an injunction against self-help measures. At that moment, either one of two things had to be true. Either the first case was pending, in which case the prior action pending doctrine applies to bar the second suit, or the first case was not pending, in which case it was final and res judicata barred the second suit. I actually don't think this court has to decide that question, because either way, there was an action in which these issues were already presented, and therefore the 2019 action is duplicative. And because of the risk of inconsistent verdicts, this case has to be appealable at the same time. There are only four possible outcomes. Ms. Rubin wins in both cases, the town wins in both cases, or if the town wins one and Ms. Rubin wins the other, those are necessarily inconsistent. There's just no way to square these two cases where one party wins one and one wins the other. So from a jurisdictional standpoint, this court has jurisdiction. We've also filed a petition for writ of certiorari, just kind of conditionally, so that this court can grant that petition if it has any concerns about its jurisdiction. Oddly, the town didn't respond to that petition. Once you get into the petition, this court can use its discretion to say, it just makes no sense to let this case be appealed at some later date, because they're all the same issue. And I think the way the argument is played out with us spilling into this next time is just like before Judge Collins, there's really no way to tease these out into two separate cases. Just like in the first case, there really aren't any findings of fact that are relevant here in the second case. Either the judgment controls from the first or it doesn't. If it does, then there's no finding of fact made by Judge Collins that's relevant in any way. There is one I want to highlight, though. The judge does, Judge Collins on record page 109, I think it's paragraph 28, said that found as a fact that there were no practical alternatives for the sewer line. We expressly challenged that finding because it's contrary to what Judge O'Neill found in the first case. It has already been decided that there are alternatives. There's two pump and haul alternatives. There's the alternative of the town condemning property to the south of this parcel and plugging into the town's main sewer line that the town had always intended to serve these properties before the developer got his nose under the tent. And there's the option to run up and around her property. So there's really no evidence. Judge Collins entered this finding of fact drafted by the town without any evidence. And so that finding, in that it's contrary to the 2015 judgment, can't stand. Yes, Your Honor.
What finding number is that?
I believe it's 28. Let me make sure before I lead you astray.
It's okay. No, I found it. I was looking at the wrong record. I apologize. I found it.
Right. It's record page 109, number 28.
Looking at the wrong record. Thanks.
So many binders.
Yeah.
So, whether it's res judicata or prior action pending, either of those gives this court jurisdiction to hear it, and either of those requires reversal of the orders. And that applies to the declaratory judgment claim and the preliminary injunction claim. Your Honor, I want to, before I move on to a couple of other points, I want to give the court a chance if there are any 2019 case kind of procedural questions. I don't want to move on without addressing those. One other issue that the town raised in our first discussion just earlier was the Statesville V Roth case. That's a case where the trial court did say not only does title revert, but the town has to leave. one analogy that I think of is kind of like when a trial court enters an order on summary judgment. Sometimes it's a one-pager, but sometimes, like in the business court, they choose to provide findings of fact just for context. They spell it out. I think that, in my mind, that's the analogy for this. Yes, could an order go and say the legal import of this order is not only that you have no right to be there, but that you have to leave? It could. Thornton says that, and Pelham both say that's redundant and you don't have to. And that's why, to kind of circle back to Judge Dillon's question, I don't think this is an issue of interpretation of Judge O'Neill's order at all. I think everybody agrees. Nowhere in there does it say the town has to leave. It doesn't say that. I'm not going to say that it has words in there that aren't there. It says the town has no right to be there and its claim to her property is null and void. And under the law, that necessarily means that the town has to leave because title has reverted to Miss Rubin.
If you could come back, Mr. Learberg, just you said that again, that Thornton says, an order saying the town has to leave is redundant, right?
Right.
Now, Thornton wasn't reviewing a trial court order that said that, right?
That's right. Thornton is many, many pages of detour through the law before it gets to the holding.
Right. But you think that many, many pages of detour, it's still on all four corners controlling here?
It does. And I think the Supreme Court later tried to distill Thornton into a little bit more of a bite-sized piece on this issue. That's why I think the Pelham case from 1981, it's 14 years later, that court reviews Thornton and says, here's what Thornton means. It means that an injunction is superfluous because dismissing the condemnation proceeding serves the same purpose. That's kind of the take-home lesson from Thornton.
But is that about a separate action for injunction being redundant, or is that about the trial court order having injunctive relief in it?
My understanding was that it was about the order, and I could be mistaken.
Okay. No,
I'm not sure if it matters.
That's okay. Okay, thank you.
Another case I just want to bring to the court's attention that's a little ironic because I was counsel in it and it involves the town of Apex, but it's town of Apex versus Whitehurst from 2011. So if anyone is on notice as to what that case says, it should be Apex. This court there said that if Apex attempted to condemn the defendant's property for a private use, then the use would be improper and Apex would have no authority to take the property under the power of eminent domain, thus ending the inquiry. So that's this court saying, kind of like what Thornton is saying and kind of like what Pelham is saying, there's nothing left to say. After you tell the town you have no right to be there, there's nothing left to say. They have to leave. That is the end of the inquiry. Well, strange that though it may seem, I'm going to reserve my 17 minutes or whatever Judge Dillon allows me for rebuttal in this case. Thank you, Your Honor.
Thank you.
Again, David Farrell here, representing the town. I'll talk about the 2019 case and then try to answer some of the questions that came up as we go forward. But, Judge Jimmy, you're correct. These are interlocutory appeals. I think certainly there's no dispute that there's some overlap between the two cases. I think the question and concern we have, and while we would ask that you affirm his orders, but also find that the appeals are interlocutory and don't affect a substantial right, is that the focus is of the review is on the orders appealed from, not the merits or the issues that they would raise in support of those. And so what you're left with here is a motion to dismiss a declaratory judgment action that I don't believe they really contest that there's a controversy between these two parties. We believe the pipe stays under existing North Carolina law that pertains to condemnation cases, to Chapter 136 and inverse condemnation. They claim that despite not asking for it, they have a right for the pipe to be removed and to use self-help. So there's definitely a controversy here.
But aren't they saying, but they're saying that res judicata from Judge O'Neill's order, which is why they're saying our decision in 304 controls this case. They're saying res judicata bars the town of Apex's claim, bars the declaratory relief. And if you look at this court's decision in the earlier appeal, where this court said you've appealed too late, and explained why the court's ruling in that 108 hearing must be immediately appealed, so that we can solve these issues about title before we're going to a jury on damages. Isn't this kind of the converse? We need to decide these issues about what Ms. Rubin's rights are before having the court spending any more time deciding what should happen, what damages she should get, anything. I mean, doesn't that make sense?
Well, Your Honor, we certainly believe that resolving the issues in the 304 case are critical and important. I think what we're looking at as it relates to the 305 case is, and when you read the transcript, you get a sense of this from Judge Collins, that he recognized that Rubin was attempting to use a judgment that did not flow from the words on the page. He was attempting to use the judgment to either require removal by a subsequent judge or justify this self-help idea that she's got. And so he recognized, based on our trying to address these issues, and again, when this was filed, he had not yet ruled in the 304 case. So that's, I mean, you asked that question procedurally.
But when 305 was decided, he had, right?
Say that again? Yeah, yes.
Okay.
He had heard the arguments, but and then he ended up signing the orders at the same time. But the way the procedural history goes, he ruled on the motions in the 305 case from the bench, and then took the rulings in 304 under advisement, and then about a week to 10 days later entered orders in the 304 case. So again, the town is faced with a landowner who didn't ask for injunctive relief and a trial judge who didn't give it to her in O'Neill, who then is coming forward to continue to use the judgment to try to remove pipe or justify self-help. And so the town believed that in order to protect the pipe and the citizens, that it needed some clarity here. And we certainly believe that the 305 action is the action that essentially could end up giving her the relief that the statutes and the cases recognize in this situation, which is a damages amount under Chapter 136-114, 111. So that's why the action was filed. The town is trying to address really a unique situation here. I mean, there's no doubt that this is not how things typically go with condemnations. But you also don't typically have landowners who don't ask for the relief they sought until after final judgment, which is what we've got here. And so, the town is attempting to protect, and this, again, the ruling from Judge O'Neill does not find that this was not a public sewer pipe. She basically found in some balancing that the private interest outweighed the public use. So she doesn't say, there's no private party that's ever owned this pipe or anything of that sort. It's in all respects a public sewer pipe that crosses her property to serve a properly annexed, rezoned, and approved subdivision with 50 houses. So this second action was really there to protect the pipe and also to seek clarification that what her remedy is, and that's damages under Chapter 136. And again, these are, this condemnation law and the cases, there's a lot of them in these areas. And I think when you look at them, you'll see that that's the result here, that we don't have these self-executing remedies that she would have you order. And the town of Midland case, the context of that in the the language that was read was in the context of the town's argument that somehow the construction of the pipe had mooted the appeal. And that's not what we're arguing here. That was a totally different situation. In Midland, the pipe wasn't installed until after the court had already addressed the parties' motions for injunction related to the pipe. So, these cases are distinguishable from those cases that have been cited are distinguishable from this case because of what the landowner advocated for. There's not a one size fits all in protecting a constitutional right. You have to ask for the relief you want. And Thornton also, Judge, you had focused on that, and I think correctly so, because what the judge in Thornton did, the trial judge, enjoined the plaintiff from proceeding with the condemnation and appropriation of the land of the defendant. So that was the request in Thornton. That's what the trial judge did, and then that's what the Supreme Court reversed and said, injunction as to action, no separate action, you bring that as a defense, and that can be the remedy of dismissal. But in that case, the facilities had already been constructed. I think they were 96% constructed, and the court said an injunction was not brought to stop that construction, and therefore that's not a remedy that the court ordered to the Thornton plaintiff. And so, again, the context here is whether or not Judge Collins, who's being asked to do something that Judge O'Neill didn't do, is going to enter a ruling that violates or appears to violate Thornton and violates or appears to violate Wilkie, or is he going to rule consistent with those cases in his mind and whether or not he exercises discretion? And I think it's also important to note, since Judge Isman, you've kind of brought the 304 case into the 305 as far as their relevance, he has a number of independent grounds in his order as to why he did not order removal. His treatment of it as an inverse condemnation was one of the reasons.
Let's just stop there with that. Okay. Is it true, as I think Mr. Learberg has said, that we would be the first court in the nation, I may be wrong, so he'll correct me on his rebuttal, to hold, among other things, that it is an inverse condemnation when government takes property for a private purpose, and the landowner doesn't elect under Wilkie to seek damages through inverse condemnation?
Well, no, I think Wilkie resolves the question, and Wilkie did not turn on the relief elected by the landowner. That happened to be the relief sought in that case. But Wilkie says, and it's interesting because Mr. Learberg mentioned his role in a previous Town of Apex case. Mr. Learberg's firm represented the landowner in Wilkie who made the request to the Supreme Court that said public use is not an element of an inverse condemnation. That was the question they posed to Judge Irvin in the Supreme Court. They said public use is not an element of an inverse condemnation remedy. Judge Irvin agreed, and he analyzed the inverse condemnation statute and said, no, our legislature did not intend to only allow an inverse condemnation remedy when there's a public use. And I mean, it's actually a cleaner case under Chapter 136 because Chapter 136 does not contain the relation back statutory references to the public condemnors. So the analysis is there. So absolutely, we wouldn't be the first court in the nation to do that. In fact, if you rule with Rubin, based on our review of North Carolina law, you would be the first court to order a pipe removed, a public sewer pipe removed from property when a landowner didn't ask for it in their relief. You'd be the first court to order a pipe removed, public sewer pipe, and not honor the settled law that says that a physical taking, a physical invasion is always a taking.
Well,
So,
if you go back to the physical taking is always an invasion, and I think you maybe cited the Bats case for this. In the Bats case, they're cutting down trees, right? They're not taking the land, right?
in Bats, they had not physically invaded the property yet in Bats, which is why Thornton distinguished Bats. The cases that we cite are McAdoo v. City of Greensboro and the Baroth Oil versus NCDOT case from 2014, which is a Supreme Court case that says, in its simplest form, a taking has always been found in cases involving a permanent physical occupation.
Okay.
So permanent physical occupation equals a taking.
Regardless of whether it's public or private, it's a taking.
Correct. Under Wilkie, that is the only conclusion to reach. Now,
And so the town of Apex, is your position, therefore holds title to the easement where its pipes are.
through the inverse condemnation right. Yes, because,
Okay.
go ahead.
Mr. Learberg said that you really had no answer for the self-help option. And I understand, that's what he said. And I understand that in bringing 20-305, you said you were doing this to protect the citizens of Apex. So can you speak to that?
Yes, yeah. There is no case in North Carolina that supports a landowner taking self-help against a physical invasion by a condemnor that I'm aware of. And
Going one way or the other.
well, there's no case that addresses, because quite frankly, most landowners recognize that a condemnor has the right of inverse condemnation, and that is the authority upon which they act. And 136-111 even says an unintentional or intentional act by DOT, which here you substitute Apex or any other municipality that has this right, unintentional or intentional act. And that's a very broad language. And again, this is the policy of the state in adopting these statutes. I mean, this is not like a constitutional facially challenge of the statute that they're bringing here. These statutes provide remedies, and landowners don't have to love those remedies, but they're here. And so, yes, there is no authority that would support giving a landowner like Rubin in this situation the right to self-help a public sewer pipe that was installed in the ground by a condemnor. There is no color of title mistake exception or quick take exception that they want to create. That doesn't exist in the law. There's no cases that recognize that. And again, you have to go back to the effect of her judgment. The impact of her judgment is dismissing a condemnation complaint. Condemnation complaints in this state under our law are judged on the date they're filed. So if you take her judgment, and I believe Judge Collins properly did in his deciding whether to exercise inherent authority here to give her this extraordinary remedy, if you look at his analysis, he said that Judge O'Neill found the claim null and void. The claim was a condemnation claim under 136-104. That, she ruled, was null and void, as if it never occurred. She did not address the pipe. So what we have to do is look at what actually happened here. There's a pipe under the ground under her property. What is that pipe? It is a physical invasion by the town. That is settled law. So, Rubin wants to take Judge Collins to task for not creating new doctrines to give her a remedy that don't exist in our law and that she never asked for.
Let me ask you, if the town just went out there and put a pipe on her property, she could bring an inverse condemnation claim.
Correct.
Seek damages, whether it's public or private.
That's right.
Can she ask the town to move the pipe?
No. There is a case that recognizes a landowner's right that if there's evidence of bad faith, it's a pretty high bar, like arbitrary and capricious that she could challenge the location of the pipe. And this is where, you know, her continuing to talk about, well, there were other alternatives to sewer really is a red herring. And it really shows that this is really more about NIMBY, not in my backyard, than anything, because she essentially, even today, has advocated that we should run the sewer across someone else's property, not her property.
But what stops the state from just going on my land and just taking my property for non-public use and saying you just got to take money? That's your only remedy. What stops them from doing that? Because you're saying my only claim is to file an inverse condemnation claim and get money, which seems flies all in the face of what I learned in constitutional law. What stops them from doing that?
Well, two things. Number one, municipalities don't act like that typically, because if you are.
They did here. They took no. Let's just say they did. Well, let's say they did let's say they didn't file the original claim. They just want this. They wanted her land. They just put the pipe down, and you're saying her only remedy is to get the money. This is a hypothetical. What stops the state from doing that?
Well, she would have an inverse condemnation claim, and the reason why.
But her remedy would not be to move your pipe because it's not public. So if the government wants to do something that's not for a public use, they can do it, and they can pay me just compensation and get away with it because my only remedy is to get just compensation. Is that what you're saying?
Well, I'm not saying it. I believe that's what Wilkie said.
So what you're saying, the North Carolina Supreme Court says if the government wants to take my property for private use, I've got to take it. I got to let them have it, and my only remedy is for them to pay me money. You're saying that's what Justice Rubin said.
I'm saying
even when the landowner says, "I don't want the money." Are you saying Wilkie says, "Landowner, you have no choice"?
That's your only remedy is to take the money. If the government wants my property for a private purpose and give it to somebody else or developer, I have to give it to them and sell it to them. I have no other remedy. Is that what you're saying?
Well, I think if you look at Wilkie had the Court of Appeals in Wilkie said that there's no remedy for inverse condemnation if it's private taking, and they were going to remand the case to the Superior Court to do this constitutional self-executing type. And Judge Rubin rejected that and said, no, we have a remedy for a landowner, regardless of whether it's public or private, and that's inverse condemnation. And so generally injunctive relief does not lie when there's an adequate remedy at law. And, you know, we can debate whether or not that's adequate in the eyes of some landowner, but you know, we have to remember the context for condemnation statutes. I mean, the condemnation authority is a powerful authority. The Constitution recognizes it, and the statutes lay out a procedure and the rights that landowners have. We actually have a statute that says if you are able to get a condemnation petition dismissed, you're able to seek your attorney's fees, which is what Ms. Rubin has the right to do. And so, you know, look, I wasn't involved in Wilkie. I'm reading the opinion just like you guys are. It says there is an adequate remedy at law, and that is seeking damages and for a private taking. And that's a 2018 case. And it dealt with the same constitutional type arguments that Rubin's raising here today. So
if I build something on your land, if you have an adequate remedy at law, you can sue me for damages. But you can't kick me off your property. Does that mean you can't get an injunction to tell me as a private to get off your land because you do have a remedy at law? You could sue me for damages. Is that? I mean,
are you talking about when you say me, like a private citizen?
Private citizen. You're saying it's different. If the government does it, they can do it. But I mean, obviously, I can't do that. You can have me thrown off your land, even though you have an adequate remedy at law. But you're saying if the government does it, it's okay. Their only remedy is to take the money.
What I'm saying is that under Wilkie, Judge Rubin recognized that if you argue that it's a private purpose taking, that you have a adequate remedy under, in that case, it was 4851. In our case, it would be 136-11.
And you would against me. You could sue me for money and not go for an injunction. That's not, but that doesn't mean that you don't have the right to an injunction. So are you saying he's saying here, there is an adequate remedy at law. You can sue the state for money and just take your money. But does that preclude you does it mean that you can't go seek the other remedy like you could against me? Is that what he's saying? He said it's different when it's the state, that's your only remedy. Because obviously you can sue me for money for trespassing on your property and let me stay there, or you could get an injunction or whatever, get me thrown off your property. But here you're saying what is that what he's saying is when it's the state, your only remedy is the money? And he's precluding the right to go have them thrown off, get them off your property if it's private.
Well, I don't believe Judge Irvin is addressing the issue of whether or not a trial court has the authority to grant a preliminary injunction to the construction prior to construction in a condemnation case. I mean, Thornton, Supreme Court case, recognizes a landowner's right to seek an injunction before construction. And so, you know, a landowner's remedy here is to seek injunctive relief and plead the things that are in the Roth case, because if the court reaches those issues, if the construction hasn't occurred, then what Rubin is asking for here about, the dismissal would have been sufficient, arguably. But what Rubin did was ignore the fact she had notice and knowledge, but she ignored the fact that the pipe was installed and didn't ask the judge to deal with it. And so when you don't do that, and then you wait till after final judgment to come in and ask for the relief that you seek, Judge Collins is well within his discretion to look at these cases from our Supreme Court and say, you know what, I'm not going to exercise my discretion and go through the effort of requiring this pipe to be dug up and removed. I mean, what Rubin is essentially asking for is for this court, and she was asking Judge Collins to read Judge O'Neill's judgment as to prevent the town in perpetuity from ever condemning an easement across her property. And that couldn't be further from the truth. I mean, the judgment deals with the date and time of the filing of the condemnation complaint in April 2015. The facts related to the July inverse condemnation, the installation and the physical taking, are different. We have a City of Charlotte v. Russo case that says that it did not apply res judicata in a case where the original condemnation was held to be invalid for a private purpose, and the city came back later and condemned the same land and had removed the private taint, is how the court worded it. And so there's just no ability to use that judgment to keep the town off her property forever. Yes,
Mr. Farrell, the City of Charlotte versus Russo, and I may have it mixed up, is that the case where the second time they came back, it was for a public park?
Yes, the first time they actually...
Like really different, right? Really different. In this case, it's just for the same development. I want to ask you what Wilkie says, or what the law says, about self-help. Is Ms. Rubin, I don't know, Ms. Rubin, just theoretically, you have a person who wants to be off the grid as much as possible, be, not in my backyard, all that, okay? Don't want you here. What is there in the law that precludes her from filling just a part of those pipes with concrete to say, you're not going to use my land?
Are you asking me specifically whether Wilkie addresses self-help?
No, I'm asking you anywhere in the law, what's to preclude her from doing that?
I believe Chapter 136-11 provides that if there is a unintentional or intentional physical invasion of a landowner's property by a condemnor under 136, their remedy is just compensation for the taking. The legislature could have built into these statutes self-help remedies, injunctive remedies, but they haven't. There is no statute or no case law that gives her the authority in North Carolina to block a public sewer pipe that's a physical invasion of her property. As Judge Dillon has said several times during this argument, private landowners, private disputes between parties have trespass rights, and you can sue for damages, you can sue for trespass. But even in the trespass action, your judgment is going to order whatever relief you get. And so I know there's this moniker from the Rubin that we won. How can we keep having a pipe on our property or under our property? But you get what a judgment gives you. And here, the judgment didn't give her the remedies that she has asked Judge Collins for after the fact. She didn't plead them, and the judgment didn't give them to her. And so, that's why not only, it's problematic for a reversal of Judge Collins's orders in the 304 case, but when you look at perpetuating these defenses that she has, I mean, it seems to me you're setting an incredibly unfair and high bar to a Superior Court judge who's looking at this after the fact and saying, this landowner didn't ask for this relief, and now they want it after final judgment. It seems like we're not really following, if we allow that, our rules of civil procedure, the settled rule and law about how you get an injunction and what those injunctions say, that they have to be specific. So we're really kind of changing the game, if you will, in litigation, because when is a case ever over? I mean, the town, Rubin has kind of said something today about our filing the second lawsuit, but I mean, they filed a federal court action while Judge Collins had these under advisement, asking for the same relief that they had asked him for. And so the federal judge dismissed it, not to wait to see what this court did. He was actually waiting to see what Judge Collins did, because Judge Collins had the cases under advisement, yet she filed a lengthy federal court lawsuit against us and others for the same relief. So, we certainly want this dispute to end. What Rubin is asking for is essentially to be free forever from a pipe, and no citizen in this state has that right. She lives in a growth area in Apex. There's neighborhoods popping up. They have a demand for housing. The fact that we connected this sewer to her property, we had a manhole and sewer 151 feet away from the residential neighborhood we were serving. So, for her to try to take us to task because we didn't run it across Mr. Walden and Cynthia Ball and some other landowners to come up around the pond through a bunch of wetlands to get to her property is just not a fair justification for Judge Collins to say, you know what, I am going to make you remove that pipe and, go put it somewhere else. Judge O'Neill's judgment does not prevent the town today from determining it needs to provide sewer to that subdivision and to determine the best way to get it there. And if that's across her property, then so be it. Any remedy that she has put up today would all require us to cross her property, except for the one through the wetlands, because Pump and Haul, we'd have to get a temporary easement across her property. If we were going to do something else, we've shown that in documents. Our engineers have looked at it. So at the end of the day, Judge Collins properly viewed the Judge O'Neill judgment, determined the situation, weighed the equities, and decided the pipe stays. And he didn't abuse his discretion in that regard. And so we certainly believe that the 304 order should be upheld. And the 305 lawsuit essentially gives her the vehicle to obtain just compensation here, which is her remedy under the statutes based on the circumstances that exist under this judgment and under this case. Again, we better avoid looking at it generally from these blanket watershed type arguments, because this case is governed by its judgment, Judge O'Neill's judgment. And that is what Judge Collins did, and we believe he acted properly in that regard. I think I'm over my time, but certainly glad to answer any questions that anyone has.
Thank you for your argument. We'll hear from rebuttal in about 17 minutes, but you're not required to use all of it if you don't want to.
I'll try not to, Judge. I think Justice Ervin would be surprised to learn that he wrote an opinion that discards the public purpose requirement from the Constitution. And in fact, there is a segment from Wilkie that I would commend to the court. It's under the North Carolina Reporter. It's at 552 and spills over kind of into 553. I won't read the whole thing, but the sum of it is that the court is saying that the condemning entity has to establish that there is a public purpose, but the private landowner does not. They have an option. And then there's a quote from the case Lloyd versus Town of Venable, which is a 100-year-old case from our Supreme Court. And I think this answers the question. The parenthetical says, the owner who consents to a taking of his property when no legal right or power to do so exists should receive the same measure of justice as in the other case where the power does exist. In essence, the landowner has an option. I still don't think that the town has an answer to self-help other than that there's no case or statute that authorizes self-help. I think that's what self-help means, though. There are many cases that would suggest that a landowner has the right to do whatever she wants on her property. And that, in this case, would amount to self-help. One of the reasons there's probably not a lot of cases in the condemnation context is that when towns lose, they usually obey the judgment. So yes, we're in an unusual situation because the town has refused to give up and refused to take no for an answer. This talk of NIMBYism, yes, Your Honor. You're still on mute, Your Honor.
And thank you for bearing with me. And you said, towns usually obey the judgment. We haven't seen a case, have we, where the judgment was entered after the pipes were all installed and the town came and took them out, right? We haven't seen this case before.
I think that is right. This is the case. This case is the hypothetical from Thornton, where Thornton says, you better be careful because you might be embarrassed if you build it. And Town of Midland. The discussion of NIMBYism or not in my backyard, that is just a bald attempt by the town to revisit something that is already decided. This taking was for a private purpose. I think the town would admit that cannot be relitigated. So questions of NIMBYism are not before this court. And in fact, this court, in a footnote in the first appeal in this case back in 2018, did affirm and say that we looked at the judgment and it looks right. It looks like this, in fact, was for a private purpose. The question of injunction came up again, and Mr. Farrell said that while Midland is about mootness, this case is not. That's actually not the case. I'd like to point the court to record page 165. This is actually from the 2015 case. Record page 165, paragraph 4. Judge Collins said, defendant's failure to seek and obtain injunctive relief prior to the construction of the sewer pipe and the town's acquisition of the sewer easement by inverse condemnation renders the judgment moot as to the installation of the sewer pipe and corresponding easement. That's wrong. That is the opposite of what Town of Midland says. And it is, this case, the argument that the town's making is all about mootness. It's all about you sat on your rights, notwithstanding the fact that the case law is clear to the opposite. But we're asking here, and we ask below, is a different kind of injunction. It is not the injunction asking them to stop construction. It's the injunction asking them to remove the pipe and obey the rule of law. And I just want to zoom out before I sit down. What the town is asking this court to do is remarkable. They're asking this court to, yes, be the first in the country to overturn centuries of state and federal constitutional law by holding that just compensation is always the remedy, always. Whether the town comes in, if they can get it through direct, great. If they can't, it automatically transforms into an inverse condemnation, whereby the remedy is still just compensation. There is no way that that's the law. No case has ever held that. That is the opposite of what our Constitution says. The town wants us to write public purpose out of the Constitution. They also want this court to be the first to construe inverse condemnation as a right that the government has, as opposed to a statutory remedy for damages that a landowner may elect if she decides that it's for a public purpose and she just wants to be compensated for it. One of the things that the town did not bring up, but they brought up several times, and I want to raise it briefly. The town says this is going to be inconvenient and it's going to cost a lot of money for them to move the pipe. That is probably true. It probably will. The cost of moving it may very well be high, but the cost of the town trampling Miss Rubin's rights and ignoring the Constitution, that cost is higher. It's higher because constitutional rights cannot be reduced to damages. There is no amount of money that can make up for Miss Rubin's vindicated right from the first case to not have that pipe there. In the end, the town's actions here, they have been unconstitutional all along for 6 years. They're disrespectful to the rule of law. They have no basis in precedent anywhere in the country. This litigation has to end. Ms. Rubin asked this court to end this litigation, end both of these lawsuits, and have this finally be over after 6 years. And specifically, we ask for this relief. In both cases, we ask for this court to reverse the orders entered by Judge Collins and to remand with clear instructions to the Superior Court to issue an injunction requiring the town to remove the sewer pipe within a reasonable time. And the only discretion that the trial court should have is those kinds of reasonable time conditions, so that we can avoid coming back here for a third time.
My question is, what authority do we have does a judge have to issue an injunction to require the state to move something they've already done? I understand they can enjoin them from building or continue to build, but I just go back to all these the Clark case that just says basically you can't tell the state to do anything. I mean, your claim is against these private individuals.
Right, and Your Honor, and I don't want to repeat myself, but the procedural options we set forth in the 2015 case under Chapter 136, the writ of assistance that requires anyone to obey a judgment, Civil Rule 70, mandamus, this court's inherent authority, and if all else fails, court. And no matter what those cases say, they cannot mean that money is an adequate remedy for an unconstitutional invasion of someone's property. That cannot be, because if that's true, then Your Honor's hypotheticals, Judge Dillon, are all correct. The government could take my house and give it to my neighbor, and all I could do is say, I want money. That's it.
I understand the writ of mandamus, but there's been no order saying remove the pipes. The only order that I see is it says that this property belongs to her. In the Thornton case, it says she has whatever right she would have against the trespassers. That's what Thornton said. And these other cases say that you don't have a claim against the state for the trespass. You have a claim against individuals for the trespasses, and they can't clothe themselves and say that we have immunity because we're following the state's orders, because the state can't do anything for, in this case, the town. I'm just trying to wrap my head around that. There is no order that said you have to move the pipe. All that I saw that Judge O'Neill's order said was she owns the property. And so that makes the state trespassers. And so what remedy do you have against the state or against the town if there's a trespass? Is it against the town or is it against the individuals that did it?
I think there may very well, under those cases, be a remedy for damages against those who installed the pipe. But there has to be a remedy for an injunction to have the property revert to its original state. And if the court's unable to find authority in the state rules, the federal constitution, we still have not heard anything about the US Constitution from the town, and it's not in Judge Collins' orders. That is a separate independent ground that gives this court that power.
Okay.
And alternatively, if the court is unable to find that a remedy for injunction exists, then we ask this court just in the alternative to declare Miss Rubin the rightful owner of her land and everything under it, with the right to exclude the town, just like any other trespasser or any other illegal entrant.
Thank you for your arguments. We will take it under advisement. Mr. Sorrell, will you adjourn court?
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
Thank y'all.
Thank you.
Thank you, Your Honor.
Thank you, Your Honors.